Good morning or afternoon at this point. How is everyone?
Hello, Your Honor. Doing well.
Excellent. So I do not want to take up too much of your time. Let's see, there's a couple of people coming in still. This is not one of the regular family law CLEs. So normally I know Ms. Davis sends everybody a little link so that you can do your CLE. We are going to try and print out a list of all the attendees so you can get your CLE, but I would definitely double check with Ms. Davis afterwards. So we'll try and have David do that. But I'm going to give it a couple of more minutes just as people are trickling in. We are in the middle of an all-day hearing, so to your advantage, we don't intend to have this take a very long time. Let me open up some things. And we are actually in our first in-person hearing all day, so everyone's very excited.
Mm-hmm.
Does everybody remember how to admit evidence the old-fashioned way?
Like what? There's a piece of paper. Yes. No, it's actually really nice to hold a piece of paper and not have to figure out how we're screen sharing it. And
Right.
That is actually.
We have a new AAG who has an in-person hearing next week, and she's like, I've never done it in a real courtroom. Oh my God. Makes me feel ancient.
Oh, we'll all be kind, whoever has the hearing. So, all right. Okay. Let me. Okay. So we wanted to go ahead and schedule this for a couple of reasons. One of them, when we first took office, we thought that it was important for us to reach out with some of our policies and how we were handling things in our court. And now that we have been on the bench for, I guess, going on 11 months, we wanted to touch base, and we also wanted to talk about some troubleshooting issues that we've had over the year. And we have reached out to members of the family bar for input on this. Because we didn't want to sort of reinvent the wheel here. We wanted to make sure we had as much input as possible from the family bar, since our job is also to help you make it a little bit easier. I know that Judge Phyllis Gonzalez is running a little bit late. I just got a note, so we will go ahead and wait for her to join us to get into that portion, but let's go ahead and get started with our other portions. And we also have Miss Almanzan and perhaps Rosie, her paralegal, here to kind of help walk through some of these things that may be a little daunting to you in terms of some of the things that we're changing here. So many of you already know the 383rd is the original family law court. So we're one of the oldest courts that are out there. So one of the things that we discovered is over the years, right now, statistically speaking, between January and November the 1st, 49.9% of all family law cases have been filed. New filings are in the 383rd. What this means practically for you and for us is that when we open our email every day, we have 140 emails a day that we're trying to coordinate hearings and exhibits and getting you your hearing dates as practical as possible, especially those that really have time constraints. So we met with the Family Bar Executive Committee and did some brainstorming there, trying to think about things. One of the solutions is, okay, we would create differentiated emails, but the reality is one more place for us and our staff to look doesn't actually make anyone's life easier. It just creates one more place that everybody has to look and remember to send an email to. So we thought, okay, so what are we going to do? And we took a year to see if those numbers would change, but the reality is those numbers are not changing. The Council of Judges is telling us that next year, the family law, all of the family law judges are expecting an uptick in close to 1,400 cases. So this is not going to get better for any of us in terms of the amount of cases that get filed. So you may notice if you get your e-filing notices that Judge Pelletier and I have actually taken to e-filing our own orders, our own hearings, our own settings. You'll see those filings come in at 8 o'clock at night on Sundays and Saturdays, and it's because we are trying to get these cases moved. So what we are doing now is we will, over the next month and a half, hopefully effective by January 1st, eliminate all the utilization of the 383DC at EP County email, the existing 383DC Gmail, and they will have some auto responses that lead you to the correct places. So don't get too anxious about it. And using Dropbox and only Dropbox. What will happen is you will have a link, and it'll be a clickable link for exhibits. It'll be a clickable link for uncontested. It'll be several clickable links that you have. And then all you will have to do is drop what you need to within those drop boxes. And in a minute, I'm going to hand this over to Ms. Almanzan and David. For those of you who have never used Dropbox, which is really quite simple, it's a very simple process. And we did have the assistance of Joe Gonzalez from the county attorneys who have been using Dropbox for quite some time. The advantages are it's HIPAA protected, so any documents that you send through there remain secure, which is very important. But the other issue is that we'll be able to quickly find things that we need there as you send them. So David, my screen, there's so many people on the screen. I'm going to hand this over to you. Are you there, David? There we go.
Yes, sir. Thank you.
Okay. And then Ms. Almanzan, I don't know how you kind of all want to do I guess do this. Why don't we have David, why don't you kind of show them right now? And this is still something that's fluid, and we got some feedback from the executive committee. Ms. Hayes was very kind to chat with me last night. Ms. Nichols was very kind to chat with me as we thought about the idea that less is more. So David, you want to go ahead and screen share the Dropbox as it currently exists and how we're working with it right now. So as you see here, what we have is we're trying to keep it as streamlined as possible. So there will be an exhibits folder, and there will be hearing requests, just like you've always done, or hearing resets, orders on entry post hearing. Those will be those orders where we set you for an EJ. And just so you know, all of our EJs are automatically 3 weeks after we have a hearing. So if you miss the date, your staff should know we've set the EJ 3 weeks after the hearing. So that's a good internal note for you all to know in case you didn't catch it or you got out of the Zoom too quickly. These will be orders on motions, no hearings needed or agreed. Motions for substitution of counsel that are agreed, motions for subservice, motions for amicus, agreed orders. If you've settled something, you can pop the order in there. And then we have another folder here, which will be our uncontested hearing. I think the only folder that we're missing right now is we are going to have a separate folder for TROs. And that is the only folder that's missing. And our goal is, if we have a separate folder for TROs, this allows us to access them quickly, get you the dates quickly, and e-file them quickly. It also means that Judge Pelletier and I can quickly go into the order on entry of judgments and the order on motions very quickly and just sign them and get them e-filed without us having to pull them from the email, download them onto a computer, send them to the judge, have the judge sign them, and then e-filing, which can delay the whole process. So this is how the Dropbox will work. What you will be getting, and we will send them by email, it will be on the EP County website, and it will be an automatic vacation responder on all of our emails, is a link. It will literally be a clickable link that says exhibits. You will click on that, you will have it, there you go. When you click on that, that will take you to the exhibit folder. Within that folder, you will upload your folder, and then we will have access to it. It does not allow you to modify anything. It does not allow you to modify anyone else's documents, but it allows you to send everything to the court. So that is the Dropbox portion in a nutshell. Are there, I guess you can stop the screen sharing, please, David. Ms. Nichols has a question. Considering the TRO, yes, that's actually an excellent question. So one of the problems that we've been having over, and I understand why it may not cross everyone's mind, but when we get an email that just sends us an order, that means we have to go into Odyssey, look at the underlying pleading, and then look at the order, which, as you imagine, takes another 2 minutes or so to correspond everything. So when Ms. Nichols says, will we upload the motion, pleading, affidavit along with the proposed order? The answer is yes. And the answer is yes to all of them. You do not just send an order for subservice, you send the folder, and the folder includes the pleading and the order. Does everyone understand what we're talking about? And that may be, I guess, when we segue to Ms. Almanzan, who was going to talk a little bit about the exhibits. But let me screen share something really quick. Can you all see that?
Barely.
Yes, Judge.
Okay.
We can see it, but we can't read it. It's print's too small.
Okay, hold your horses. I'll make it bigger. There we go. Is that better?
There you go.
Okay. So what we don't want to happen, particularly with the exhibits, is we do not want you to upload 24 different Dropbox exhibits into the exhibits. And this is where Ms. Almanzan will show you exactly what's going to need to be done. You're going to create a folder, just like I don't know how you all do things internally, but when you create that folder, make sure you're identifying, 2022 DCM 1234. In it, you'd have petition and suit and temporary restraining order for signature, or hearing reset form, or final decree of divorce for entry of judgment. Within that folder is what you're going to put all your documents in, whatever it is, affidavits, pleadings, motions, and orders. Then you upload that folder into the Dropbox so that we have everything in one place. The big other issue that we have that happens quite frequently, and this is something that I think the paralegals really need to look at. When you save all your documents, it really helps us to save it as, instead of, SXF36, some random number, or Smith temporary order, because you know what Smith temporary order is, but we don't know what Smith temporary order is, or temporary order is number 12, to call it 20 cause number and then the title of the document. When you do it, it allows us to e-file things that much quicker because we don't have to resave every single document with a new cause number. Because we have to download, rename them, pull documents from Odyssey. And this is just so that we can be sure that you all get your hearings as quickly as possible. Okay. Are there any, Ms. Sprague? Yes, we will have, okay, hold on. Now I'm backing up. Yes, you will still need to share exhibits with opposing counsel because right now, the way that Dropbox works, we are not able to share with two people. You're uploading to us, to our Dropbox, and that's the way it's working. You are not uploading and sharing with other individuals. Now, that being said, you could send the same Dropbox link, I suppose, to opposing counsel since you've now created the folder, which makes life a whole lot easier. Ms. Sprague, yes, we'll get all those Dropbox links. What we're planning on doing is we can drop them in the chat. but we will most definitely send that out in a mass email. Ms. Nichols' staff has been very gracious in helping us in this entire arena and sending out. Excellent question. I do not, well, Judge Strathmann and Judge Gonzalez don't really have a whole lot of exhibits they get from the private bar as a general rule. So they do not have a Dropbox link to my knowledge at this point. They will continue to use their emails. But at the end of this, they are doing a presentation on their best practices. So that will be a question we can probably bring up to them. Esther, no, do not scan as one document. Please, and that will be another segue to Ms. Almanzan. When you scan 40 documents together as your exhibits 1 through 24, that means I have to look at the documents before they've been admitted, which sort of defeats the whole entire purpose. You have to have each exhibit separately labeled. And I think on that note, I'm going to pass this off to Ms. Almanzan and Rosie.
Thank you, Judge. And I have Rosie logged in as well, Your Honor, and because she is the real expert on Dropbox, not me. And so Rosie's my paralegal and she's logged on, and we're just going to go over kind of some basic creating folders in Dropbox, sharing links to the court. We have been using Dropbox for a couple of years now. We decided to try and go paperless right before the pandemic. And so we started putting everything in Dropbox. And so Rosie will go over creating the folders, and just to kind of address some of the questions that were in the chat. When we send the Dropbox link to the court with our exhibits for a hearing, we copy opposing counsel on the email. So it's an easy way to send to opposing counsel as well as the court the link for all of the exhibits for the hearing. And so Rosie, if you're ready, Judge, does Rosie have the ability to share screen?
Yes, I enabled that.
Okay, great. And Rosie, so if you can share the screen, and we can, if you have your Dropbox open, so that we can go over just briefly creating folders and things of that nature. Okay, we might be having technical issues.
There you go.
Okay.
Can everyone see it? Yes.
Okay.
Okay.
So Rosie, if you could go over just creating the folder, and you, as you can see, we have all of our exhibits and everything labeled with the cause number, as well as what the exhibit is, or what kind of motion it is, or order. And additionally, we also have a summary of relief requested, an example of one that Judge Ness Garcia has asked us to kind of quickly go over, just so that you can see what we do when we're requesting relief from the court. It makes it a lot easier when we send it to the court in Adobe. The court can then look at the summary of relief requested and notate on it themselves what has been granted and not granted. So Rosie, I don't know if you want to go ahead and talk about creating folders in Dropbox.
Of course. So for instance, all you do is right here, you click on add, you add a folder. And so what I do is we go ahead and put in the cause number. And then what I do is I put like petitioners exhibits. Okay, and then within that folder, you could add obviously your exhibits and your exhibit list, your summary relief. We do have a summary relief that we do enter for temporary orders for a final hearing. And so it might change at a final hearing or not, but this is what we do. And this is what we enter as an exhibit.
And so Rosie, how would you move like that summary of relief requested into the folder you just created?
Yes. So what I do is I just right click. And so I usually just copy. Usually our exhibits are like in an evidence folder. that the client has given us. And so from there, I copy and paste, and then I put it into our exhibit folder.
So you
And so
right
that's
click
what I
and
do.
then paste.
And then paste, yes, correct. And then, so if you want to, for instance, if you want to redact something from the, actually, let me see, let me go into my, so in order to redact anything from your exhibits, you would need, we have the Adobe. And so we open up the file, and so what we do is there's a redaction tool. And so if you want to redact anything from there, you just do so. And so you click on it, and then it'll give you the option of just highlighting it, and then you apply it. And then it does that, and then it saves it into that same folder as a redacted file. And so you
And
can
then
just,
how about labeling the folder as well?
and then labeling the folder as well. So what we do is within the actual PDF file or document, we label it. So what I do is there's an edit PDF. So what it does, it's kind of converting it and it's scanning it. And so what I do is I just add a text to it. And so you could either put it on the top or the bottom, it doesn't matter. So what I do is you could change the font, the color. And so what I do is I put, P1, if that's what it is. And so then you just save it. And then you could just close it. So when you open it, it's going to have that redaction. It's going to have the exhibit name. And so that exhibit number should correspond with your exhibit list. I mean, my exhibit list right now is just a random. It's not going to, be the same as my exhibit number that I just put. But this is our exhibit list.
And Rosie,
so click on the exhibit list and open it,
yeah, because we can't see it.
You can't see it. Oh, I'm sorry.
or just open the exhibit list.
Oh, I did open the exhibit list. Oh, how come I can't see it? Can you see it?
Nope.
Show. Let me see. Sorry.
You've got to switch what you're sharing, Rosie.
Yeah, there you
Okay,
go.
Did it work now?
Yes.
Okay, got it. Okay, so now this is our exhibit list. And so we put P1, and then it's got, the table, it's got marked, admitted, and then the description of the exhibits. So this should reflect what you have as an exhibit, your exhibits in your folder. And so usually what I do is this is the only document that's in Word, and the actual exhibits are PDF. So we convert them if they're in, in another format, then we just convert them into a PDF document.
And how do you do that?
Yes. So let me see, for instance, like this one, let me see, are you? That one. Okay. So can you see this one?
Yes.
Okay, so it's a motion for other substituted services. This is my Word document. So what I do is I just click on Save as Adobe. So when you go to the actual file, Save as Adobe, so it does do that, and then you could just save it. So what I do is, within, internally, it's not saved this way because, it's just the way we do it. It's saved under our client's name, but I learned to now save it, the way Judge Garcia wants it. She wants the case number, and then she wants the name of the document. So the case number, and then the motion for other subservice, and then you just click save. And then it will save it. It converts to the PDF, and then it just saves it. And then so that is how.
And then Rosie, can you show us, you talked about redacting and you talked about labeling the actual documents with P1, P2. Can you open those so that we can see what you labeled and what you redacted? Because we weren't able to see them.
Oh, okay. Sorry
And
about
so
that.
one of the things about having that exhibit list that helps us is we don't have to look at the exhibits beforehand. So if we have that exhibit list, I tend to print it out and I use it manually, but I also then give it to Bob afterwards so that Bob knows which exhibits were admitted and he can pull those exhibits if he ever needs to do a transcript. And I know Rosie already said it, but those exhibits have to be in PDF. If they are not in PDF, it takes Bob an extra 3 or 4 hours in order to create a transcript because of the mechanisms. Don't even ask me why or how it all works because I don't know enough about court reporting, but he has to print them out and he has to rescan them, and it's a very laborious process. If you send your exhibits in PDF, you'll get your transcripts much quicker. That I can tell you.
Yeah, and it just, Judge, we have Adobe, so it makes it a lot easier if you to go ahead and convert any Word document to the PDF. As you can see, Rosie showed, it's very, very easy. And then, Judge, this is one of our summaries of relief. And this shows you the redaction abilities of Adobe as well. What I've used this for is, for example, you have a text message, but one part of the text message is hearsay, or one person's portion. So I've used the redaction to remove that person's portion because I still want to enter the rest of it. And so that's what we've used the redaction for. But this is an example of a summary. And Judge, you've used this to mark granted or denied, and then so that we knew what the ruling was and then could prepare the order based on the court's ruling. And Rosie, can you scroll? And then you can also see on this that she marked it P1 at the top. That is just simply, again, on Adobe, adding text to the document, and you can put your client's name one, petitioner one, however you want to label it, but it's just easier when you're in the hearing to keep everything organized and it corresponds with the exhibit list that you've provided. But Rosie, if you could scroll down just to kind of show you, in the summary, we address the possession and access, the child support, everything of that nature. It just kind of summarizes it for the court. And honestly, for me, just so, and when it's a divorce, the property, the debts, all of that stuff is written down so that we're advising the court what we're asking for. And it helps me during the hearing to make sure that I've addressed everything that I wanted to address.
It also saves time because it means you don't have to ask your client about the 5 different vehicles. And,
Right.
I usually allow you to kind of synopsize if you've given me one of these. If you notice, Rosie had also included a Word version of this because here at the county, they don't give us the high-end Adobe. We only have basic Adobe, so we can't edit in Adobe here at the county, just so you all know. So giving it to us in Word allows me to kind of use this and cut and paste and keep track of all the documentation that we need. That's why on those large, big contested final hearings, we are requiring the requested relief.
And Judge, I don't know. Oh, and then Rosie, if you could go over emailing the link to the court and how you do that.
Yes, ma'am. So what I do is, let me see. So I'm going back to the actual folder.
And if you could show that to us, Rosie, we can't see it.
Okay, can we see it now?
Yes.
Yes. Okay. So what I do is, let's just say this is what I'm going to, this is a folder that has everything in there, the exhibits, the exhibit list, they're already marked, they're already redacted, whatever you needed to do. So what we do is we just copy the link. So we right click and it says copy link. So when we actually go to our email, then we just paste on the email, on the body of the email.
And we send that to the court.
And then we send that to the court and to opposing counsel or opposing party.
Okay. And then in the link, the court can just click on the link. Court reporter could click on the link and everything is labeled. As we showed, P1, P2 with what it is, and everything's in there just in case, depending on what is entered into the hearing, but everyone has copies of everything we intend on entering, right?
Correct.
I know this seems like a lot of information, and we just wanted to give you an idea, but, and of course, we haven't provided Ms. Almanzan the copy of the link, so she can't show you how you would upload. But we wanted to kind of just give you an idea of how that's going to work. Dropbox, you do not even have to have the Dropbox app to use it. So pro se's can use it, anyone can use it. But when you have that link, you're literally going to click on exhibits and upload, and it's going to say, what do you want to do? Upload. And that box, that folder that Rosie just showed you that said 2021 exhibits, she would upload it and boom, it would be in Dropbox. And you can't, nobody can modify it except the court. So it's all secure for us. And we have the business, we have the high-end business. So it's there for all of eternity that we need it. So everything is going to go through Dropbox from now on. We will not be using personal emails that you may have accumulated over the years. We will not be using the Gmail. We will not be using the EP County email. We are going to transition. So don't get scared. This isn't happening tomorrow. Our goal is to make this the sole mechanism of submitting to the court effective January 1st. We will probably maybe do another presentation just on the nitty gritties of Dropbox for everybody again in the future if you need to. I know that change can be scary, but trust me, it will mean that everybody gets what they need a whole lot quicker. Thank you, Rosie. Thank you, Ms. Almanzan, for that. That is, the court really appreciates you kind of explaining how we want those documents to be compiled. And I'm sorry to sort of push along, but I know we have 2 Title IV courts who have dockets this afternoon as well. I did want to address, because I have a docket that's going to start soon too. We want to remind everyone, and I know it goes without saying, Zoom protocol. Please practice with your client before you come to court. It's been a year and a half. At this point in time, having your clients in their car, wandering around outside with wind blowing, we can't hear them. We can't get a clear record. It has to stop. I recognize the beauty of having someone take a break in their busy schedule, but have them find a quiet room wherever they work. Make sure they have connectivity. Have a staff member in your office. Just practice with them the day before so that they know where their video is, where their mute button is, where the basic things, and remind them it's still a court hearing. No tank top. I mean, dress as if they're going to court still. Okay. Yes, Mr. Mullen.
Judge, just don't call it a dress rehearsal. I talked to one of my clients one time, and I told him I wanted to do a dress rehearsal, and he didn't know what I was talking about. It's generational.
We have, if we will allow you to appear remotely as long as you want to appear remotely. We are doing hybrid hearings in person. However, if you want to appear remotely, we are going to get a whole lot more strict about the quality of your hardware. Please make sure you have good devices. I can tell you, Ms. Almanzan, Ms. Walker, both of them have these great earphones with mouthpieces. The beauty of those is it really cuts out all that extraneous noise. Sequester your dogs, Ms. Davis. I mean, these are things that just start making life harder. If you want to appear remote, I am more than happy to let everybody appear remote, but make Bob's life and our life a whole lot easier by meeting us halfway on it. So invest in high-speed internet, invest in a good microphone, invest in a good camera, invest in all of those things. They're not that expensive if you want to continue doing that. You now have the right to come to our courtroom, have a hearing in person or hybrid as well, just so you all know. Two things that you all may not know, there are 2 standing orders that were issued by the 383rd, and I will have those sent out, or actually, David, do you think you can drop them both in the Dropbox? I think I put them in our standing order file. All cases that have OAG intervention or that are filed by the OAG are automatically going to start with the Title IV court, be it the 808 or the 806, depending on which court it is. So No longer will they be starting up here and referred back. So if the OAG files a new action, it's going to start with the Title IV court. We now have a standing order, so the district clerk should be getting those filings done, and you should be seeing that happen more and more. The same thing has happened with the DRO and any of their actions, just so you know. For our court, the DRO enforcements are all child support enforcements, I should say, or where they have Title IV services. All of our cases have been referred to Judge Strathmann for her to hear them. And I think, was it the 65th as well? I'm not recalling. And the 388th, and I believe one of the other courts, they're all going to Judge Gonzalez automatically. And we'll send you those standing orders in the chat, just so you know. Let's see, other little minor things. You please look at your hearing requests. On de novos, we are going to be a whole lot stricter and moving these cases. Our de novos will be set for dismissal 45 days out after de novos are filed. If you do not request your setting and you don't show up for that dismissal, we're going to start dismissing those de novos. We've had some that have been languishing a really long time. If you have a final hearing that says final hearing / dismissal with the mandatory dismissal language, you cannot reset those by agreement. They're mandatory final / dismissals. So what that means is you do need to show up before that hearing date or have somebody show up in person on that date to give us a really legitimate reason why you want another reset. I can promise you these are only cases that have really been sitting for 2 years, 3 years, and we're really trying to move them. Do not forget the OAG signature. I'm not quite the stickler that Judge Herrera was, but if there's any OAG involvement, you need their signature on orders. If they have an intervention, if they have a pleading, they are a necessary party. So please make sure you are including them. And that's kind of it. In terms of moving forward, we are trying to work with the district clerk on eliminating tracks, since a lot of other counties don't use tracks. We'll keep you all posted on that. But I don't know about you all, but the tracks make us crazy. And so if we get somewhere with that, we'll let you know. And on this, any questions on anything we've kind of talked about before I move over to the Title IV courts? Nope. Excellent.
I do have a question.
Yes, Ms. Thomas.
Okay. I want to ask if we have an in-person hearing, do we have to send everything by Dropbox or not?
No, you do not. If you have an in-person hearing, you may bring your documents in person, old school, just like we were in court.
Okay. Thank you.
Of course. So, I'm gonna, I guess, transition over to Judge Strathmann and Judge Martinez Gonzalez. Just as sort of background, Judge Strathmann has the 808 docket. Judge Gonzalez has the 806 docket. The 807, I don't know if we ever fully resolved what's going to happen with those UIFSA cases, but we'll kind of be figuring those out. And Judge Strathmann also has the Culbertson Hudspeth docket, in case you did not know. We will be requiring, and I should also preface this, everything we are talking about here only applies to the 383rd cases in front of the Title IV courts. I'm not speaking for a CC5, the 388th, or any of the other courts, okay? So I do need to make that clear. So we will, if they're long hearings, waiver of appeals, just like we do with Judge Pelletier. Both of these courts really want to let you know that we are moving beyond the philosophy of a standard possession order. They want to be just as creative as the associate courts are in all other family law cases. So don't be scared of having your hearings there because you think you're just going to get an SPO. They are absolutely open to a lot of creative thoughts and ideas. And so we're hoping this will help the docket move faster there. For the 383rd, we don't plan on using the DRO for referrals for access and possession unless the parties ask for them. We've just had so many problems with getting those incorporated as enforceable orders under In Re Slaven. And so until we clear that up, unless your clients want to go to the DRO, we're not going to make them go. And you may know Larry Dominguez. I'm not sure if he's on here. He is currently working as a bailiff for both of those courts, and he is here in person. So if you do need anything, you can also reach out to him. But passing it over to however they've decided their presentation.
Thank you, Judge. So my understanding was that Judge Garcia had wanted Judge Gonzalez and I to go over the elusive child support review orders so that the attorneys would better understand what those are and what the process is. I have the part of the agreed and Judge Gonzalez has the part of the non-agreeds. So what I'm going to do is very quickly, I'm just going to kind of run over the statute so that way you guys know where it is, and my presentation mimics the statute. Let me see if I can share my screen. Oh. All right, well, maybe I can't because I'm on my Mac. Essentially, the purpose of they call it a CSRP, the Office of the Attorney General call it a CSRP, and it's a child support review process. But ultimately what comes out of it is an order, a child support review order. And the Texas Family Code has a process for which the Office of the Attorney General goes about having these conferences with who the Office of the Attorney General calls customers. And that is the parents of the child or children. And they have this process of having these conferences and trying to work out agreements before there is a court case initiated. And so the purpose of those conferences is to establish, modify, and enforce child support orders and to determine parentage. These child support review orders that come out of the Office of the Attorney General are enforceable as any other court order. All of this is in Chapter 233 of the Texas Family Code. I did send a paper, Judge Garcia. I don't know if it got opened. I tried to share my screen, but then my Mac started telling me all about preferences and funny things like that, so I wasn't able to.
Judge, I have 233, just parts of what I have. You want me to pull it up to see if you can use that? Maybe.
Let me just see. No, it wants me to open system preferences, so I am going to not.
Did you
Sure.
send a paper? What email did you send? Oh, there you go.
I sent it to David and on. It doesn't matter. So I can just run through it. All right, and so
Okay.
the 40 agency has to issue notice to whomever would be entitled to notice under Chapter 102 of the Texas Family Code. The notice has to describe the procedure for the child support review process. It has to inform the recipient that they can be represented by legal counsel and that the recipient may refuse to participate in the process, but if they refuse, that it's not going to prevent the process from going forward. Those are required notices. Things that could also be included in this notice to a person who has a child that is receiving or going to be receiving services from the Office of the Attorney General is that the person may be informed that an affidavit of financial resources must be completed and returned to the agency within 15 days. But if they don't do that, then the agency is just going to go ahead and use the resources they have available to them in proceeding with the conference. And service of this child support negotiation, this child support review that's going to happen can be served either by personal service or first-class mail. Does anybody have any questions on that notice that people are receiving that they're going to come to the child support review office and have a conference? Okay, so I broke it down into different kinds of cases. Paternity cases, what the notice is going to say is there's an allegation that you, person who's receiving this notice, is a parent of the child. And it says that not later than the 15th day after you receive this notice, you have to contest this from happening or admit to being the biological parent of this child. If a party timely denies parentage, then either they can request or the 40 agency can request paternity testing. The 40 agency will go ahead and arrange that paternity testing and will give everybody notice of the time and place of the testing. If either party fails or refuses to participate in the 4D testing, the 4D agency can go ahead and go forward with this negotiation process and go ahead and resolve that question of parentage against the parent that decided not to cooperate or participate. If the results end up identifying the parent as a parent, then of course they move forward. And if the results exclude a person who's been pointed out as being a parent, then the 4D agency must enter an order declaring that that person is excluded as being the parent of the child. So that's whenever the paternity is in question. When you have acknowledgement of paternity cases, the notice is just going to say, look, this is the amount of the periodic payment of support that's due. You have been identified as the person that is going to be responsible for the payment of this support. And the only thing you're going to get to contest is the amount of that monthly support payment. If the person who receives that letter does not contest within 15 days after receiving that notice, then the agency can go ahead and file a child support review order with the court. The enforcement and modification cases, they're going to get a notice. It's going to say, hey, this is the amount of periodic support that was due. This is how much is overdue. This is the amount that needs to be paid for current support. And this is the amount that needs to be paid towards the arrearage. But it is also going to tell the person, hey, if we've gotten this wrong, then you can go ahead and contest this if you're not the responsible party, if the dependent is no longer entitled to support, the arrearage is wrong. And if that person is identified as the person responsible for payment does not contest that negotiation within 15 days, then the agency may enter a child support review order. So the grounds for modification and enforcement are the same as Chapter 156. The information, so that those are the different types of cases. Now we're to the information that's going to be provided. So whoever's received their notice, this is the kind of case that's going. They get to the conference, and when they get to the conference, they're to be told this is a conference in an attempt to reach an agreement. If an agreement is reached, a child support review order will be prepared and effective upon becoming confirmed by the court. And if it's not reached, then the 4D agency may file a review order without your agreement, and that party may request for the court to have a hearing on that non-agreed order. That is Judge Gonzalez's part. So I'm going to keep just going over, and she will come back to that and go over that whole process. They also are going to be told a party may file a motion for new trial not later than the 30th day after an order is confirmed by the court. So there's two things on this. One is that the only thing that ever crosses my mind is these child support review orders generally receive the cause number. When the child support review order is presented to the court, it's all done in one package. And so there's always a question as to how quickly people are going to be able to find that child support review order has been filed and what the cause number is. I'm just throwing that out there, but that's there. The second thing is in the statute, it's very clear. The notice is a party may file a motion for a new trial not later than the 30th day after an order is confirmed by the court. The reason why it's a motion for a new trial is because a de novo appeal is not appropriate in these circumstances. You do not file a de novo appeal of an agreed child support review order or a non-agreed child support review order. And the reason is because your de novo suggests that the associate judge somehow had some error in coming to their conclusion. And the thing is that Judge Gonzalez nor I had anything to do with that order that ended up coming out of the 4D agency. Therefore, there's nothing to point at that we got wrong that the district court needs to go ahead and take another look at. So that's why a de novo appeal is not appropriate ever with an agreed or non-agreed child support review order. The only way to contest an agreed or non-agreed child support review order is with a motion for new trial. So the record that will be had from one of these negotiations is simply the documents that the 40 agency relied on, maybe any affidavits of the parties, as I had mentioned before, but there is no recording of the proceeding. All right. So the 40 agency can also make a finding that no order should be issued for whatever reason. Now, let's say that they do get a child support review order. If they end up with a child support review order, there are things that must be contained within that order. Number one, it must be signed by an attorney for the 40 agency. Generally speaking, these negotiations are not being done by lawyers. They're being done by child support officers that are trained, highly trained, in the policy of the Office of the Attorney General and in understanding what the statutes are and how to calculate child support. These child support officers are immersed in everything that we are. They're the ones who generally do the negotiations. And that's why I believe that there's this specificity within the statute that says it must be signed by an attorney. So attorneys do review them. But generally speaking, again, it's a child support officer that does the negotiation. A child support review order for enforcement may not contain provisions of contempt, fines, or incarceration. And a child support review order that's not agreed to can reserve issues of like conservatorship or possession or whatever for a final hearing. Now, if the negotiation results in an agreement, each party must sign it. Each party has to sign a waiver of service of process and court hearing. And the mailing address of the party must also be in the child support review order and the following statement. And it says, I acknowledge that I have read and understand this child support review order. I understand that if I sign this order, it will be confirmed by the court without further notice to me. I know that if I sign this order, it will be confirmed by the court without further notice to me. Did I write that twice? I know that I have a right to request that a court reconsider the order by filing a motion for new trial at any time before the 30th day after the date of the confirmation of the order by the court. I know that if I do not obey the terms of this order, I may be held in contempt of court. That has to be in all caps and bold or underlined. And so all of that is in the contents of a child support review order. Now, the reason that there's a waiver of service of process in a court hearing is because they let them know, hey, look, you're not going to get any other notice, just like it says in that big statement. All that's going to happen is on this day, we're going to go and present this to the judge, and that's it. C'est la vie. So, if a negotiation results in some but not all issues being resolved, the parties may sign the waiver of service along with an agreement to appear in court at a specified date and time for a determination by the court of all the unresolved issues. Again, at that time that they are at that negotiation, they will get the agreement to appear in court. There will not be a future notice sent to them of that court hearing. They will only receive it at that negotiation that day. All right, and so they've done it, and they're at my part, and my part is, yay, it's agreed. So what happens is the child support review, the child support agency goes and takes the child support review order to the court and goes ahead and presents it to the court. Now, let's just say there's an out-of-state order. The way that the statute is written is that if you go ahead and attach an agreed child support review order with a child support order issued from another tribunal, then that agreed order is going to be treated as a confirmed order without the necessary necessity of registration. So all those steps don't have to take place if you're dealing with another tribunal's order and you have your agreed order. So that's just a little side note. But anyway, so let's just say it's a regular case and everybody's from El Paso. You go ahead and go to the court, or you submit it, however you submit it. The court receives it. Upon the filing, and this is really all Judge Garcia had me here to tell you guys today, other than the part about the de novo hearing, is on the filing of an agreed child support review order, the court shall sign the order not later than the 7th day after the filing of the order. The order is considered confirmed by the court by operation of law, regardless of whether the court signs the order. So once an agreed child support review order is filed, and agreed is filed 7 days later, done. Unless somebody files a motion for a new trial within 30 days and gets that granted. Now, let's just say somebody files a motion for a new trial and the court grants the motion for a new trial. The agreed review order constitutes a sufficient pleading for the 40 agency on any issue addressed in the order. Just so you know. So don't expect that you're going to get a motion for new trial or a counter motion from the 40 agency. They don't have to. They get to use the review order as their pleading. And so with that, I've kind of walked you up to the point of, and then what about these non-agreeds where you have somebody who doesn't want to agree and walks out of the negotiation and says, you know, I'm going to go hire a lawyer. Judge Gonzalez?
Yes, thank you, Judge. You did a lot. Thank you. I appreciate it. Can everybody see the screen? I hope so. Okay. So this really is just the nuts and bolts of the statute, much of which Judge Strathmann went over. The initiating administrative actions of the Title 40 agency. I'm just going to say OAG because that is the Title 40 agency for Texas. I'm going to go down just briefly because she went over a lot of the information. Oops, sorry. Let's see, here we go. If I can get, I'm not used to doing this. Let's see. If I can scroll down, there we go. Okay, so really quickly, and Judge Strathmann hit the nail on the head with regards to what can you do if your client is there. And don't forget, you can participate in these conferences with the Attorney General's office. And so, but like she said, most likely the conference will be with the child support officer, not a lawyer, not one of the assistant attorney generals. If an agreed CSRP was rendered, you do have 30 days after the court signed the order to file a motion for new trial if you wish to do so. But one of the things that I have concerns about is the waiver of service that your client might sign, which is going to be, let's say the person doesn't agree with something and they're going to sign a waiver. And the statute says there needs to be a specified date and time for the court to determine all of these unresolved issues. Most of those will not have a specified date or time. So unless the court gives the Attorney General's office that information to go ahead and have that. But what's important here is the notice of hearing is not required. So if I'm going to get a non-agreed child support review order and I see a waiver like this, I will set it for a hearing, only because this specified date and time for the court to determine any unresolved issues was not in that waiver. And so that's something that I do in my court, and I think Judge Strathmann does as well. Just so that you know, when you file a notice, a request for a hearing, when your client has been served, or they call it delivered, the order, you have 20 days to request a hearing, and it's 20 flat days straight. 1, 2, 3, 4, continue to 20. And when you file that request for a hearing, that will stay any confirmation of that non-agreed child support review order. And so then we're going to wait for a hearing. The hearing should be heard within 30 days of you filing your request for a hearing. If by some chance it gets reset, then the court needs to hear that within the next 30 days of that initial hearing. So the purpose of this is to make sure that this is an expedited process so that cases get resolved in a timely manner. Now, I think for both of our courts, any kind of written document that the court receives during that time frame, we will consider that a request for a hearing. And so someone had mentioned something about de novo hearings. When you request a hearing from the 40 courts on any of those issues, you can be very specific. Any issue in dispute will be heard as a trial de novo. And then you can also limit the scope of what your issues are. It can also be everything, depending on what the request is going to be. I'm pretty lenient when it comes to these non-agreed CSRP review orders, because what happened maybe 4 or 5 months ago, the circumstances may definitely be different now when I hear the case. And so I'm trying to see the time. Oh, it's 1 o'clock. So once you have a hearing on the non-agreed, and they call it a petition for confirmation of a non-agreed child support review order. Once the court has a hearing, it's going to be a few things. It's going to be, the court says, this is a good order, it's good to go. They're going to sign it as is, and then they're going to do that immediately. Let's say you have a hearing, and if the non-agreed as it was presented was not appropriate, then the court will definitely go ahead and at the conclusion of the hearing, sign an order or shortly thereafter, and then with their rulings of anything that was changed on the order that was submitted with the court. If the court decides that all of that relief should be denied, then not only will the court have to enter an order denying that relief, but they also have to have specific findings explaining why it was denied. If the party, and I think this is one of the important things on section 233.027C, subsection C, if you are the party who requested a hearing but didn't show up to that hearing, all the court has to do is sign that non-agreed child support review order as it was submitted. And that's it. Doesn't say you have to have a hearing, doesn't say anything. So when that gets signed, then you might want to start thinking about the timeframes that you have, which would be the 30 days. So I just did some really quick tips for non-agreed CSRPs. First of all, you have a client and you want to get your code book and go to section 233. Number 1, ask your client very simply, did you receive a letter or a notice from the AG? If they did, you want to look at it. Did you go to the CSRP conference? If no, then you're probably going to be looking at a non-agreed child support review order. If they did sign documents, then you might be looking at your client who possibly signed an agreed child support review order or a non-agreed child support review order. You have 20 days to request a hearing once your client was served or delivered a copy of that order. The hearing's got to be held within 30 days. If the hearing is reset, it's got to be heard within 30 days of that initial hearing. You treat the hearing as a de novo hearing that can limit the scope of the hearing on any specified issues that are in dispute. Any timely request, again, will stay any confirmation of the non-agreed child support review order. So sometimes I'll get a lawyer saying, I want to vacate that order. Well, it was never an order of the court because it was never confirmed. When you request a hearing or any document, the court's going to consider that a request for a hearing, and that's going to stay that confirmation of the non-agreed child support review order. And then I think one of the other important things, if the hearing is not timely made, the court can still sign and confirm the order within 30 days after the last person was served with that petition for confirmation. And then, of course, just like what Judge Strathmann said, even on an agreed CSRP, you have 30 days to file a motion for new trial once the court signs or confirms that child support review order. And I went through this really quickly. I can give this to you, but those were like the nuts and bolts of what I think would be really important for you when you have a client, just kind of gauging what they did or what they didn't do or what to expect, because you might not know exactly what happened, when they went to that conference. Was there any questions about anything? I know I went really fast.
Ms. Rios had a question. I think it was the conversation, Judge, we all had when we were preparing for this, which is you have a client who's gone. They've agreed. And this is what started the whole, I think, with the case that Ms. Rios and Ms. Davis had. He agreed. That night, things changed, and he decided he no longer agreed.
Mm-hmm.
There was no cause number yet assigned.
Right.
What does he do? And at this point in time, we were all still COVID, so there wasn't like an office he could at least walk into either. How do you let the court know that you are no longer in agreement to that agreed CRSO that you've just signed?
Before any of the child support review orders are filed, it's in the hands of the AGs. Right? They can vacate an order up until the point it's been filed. Once it's been filed, then you're right. That's when you get assigned the cause number. That's when it goes to either Judge Strathmann or myself. I would say file immediately, a motion for new trial. I mean, because that's really going to be the only recourse at that point. Right. When it's a non-agreed child support review order and your client has been served, that's when you have 20 days to file your request for a hearing. It's an answer, right? It's just saying, look, I don't agree with this. I want to go before the court, and you can limit the scope of what it is you didn't agree with, or you can be wide open. It really depends on what you want. And then there's the timeframes that you need to hear the case. Once the judge renders their orders on the non-agreed child support review order, you still have another 30 days to file a motion for new trial if you wish to do so.
And I guess maybe that was my question in the chat. Was I was a little confused on the 20-day time limit. Was that after, I'm assuming then after he gets served, right?
Right.
And it's not necessarily 20 days from the date of this the
No.
child support review.
No,
Okay.
it's right. But that's the thing to be, because let's say your client signed a waiver, right? That one that says, oh, I signed this waiver and it says I'm going to go to court, but it doesn't give you a court date.
Correct.
Right. Well, then technically that is when your client was delivered the order along with the waiver, because that's what the waiver says. You know, I gave your client this waiver, I gave the order, all of that. Then your time clock starts ticking. So I would tell them, don't sign anything. If you don't agree, don't sign, because if you don't sign anything, then they have to serve you, or you need to sign a waiver.
And that was my confusion, or maybe thanks for clarifying that, is that you're saying 20 days, you have 20 days to file a request for a hearing. But if, let's say they go in, they don't have or they're given an order, but the order doesn't have a cause number, how are we supposed to request to the court
Well, that's when you have to wait.
that we don't have a cause number on?
Right.
we
Okay.
still
So
have to
at that,
wait.
right at that point, if it's an agreed CSRP and it has not yet been filed with the court, because remember, you know, it's going to go with the child support officer, then it goes to the AG. Okay. And then after the AG signs it, then it's going to go get filed with the court. Okay.
Correct.
So before it gets filed, it's in the hands of the Attorney General's office about whether to vacate that order. And they still can do that. But until it's been filed, or once it's been filed, then it's going to be, you got to file a motion for new trial. If it's an agreed CSRP, if it's a non-agreed CSRP, then you're going to be asking for a hearing on any of the issues that you want to discuss and have before the court.
That little flow chart, I think that you had, Judge Martinez Gonzalez, is extremely handy. And I think you have to pull out your family code each and every time and follow along that statute, because the remedies for agreed and non-agreed are very different. But at the end of the day, I think the big takeaway is de novos are not the way to go on either of those, because the judges really haven't heard anything. The way to go is those motions for new trial. And I think that's one of the big takeaways that I know a couple of folks have gotten burned on, because that's such a particular statute for the Title IV courts and those
Right.
CR subs.
So let's say
On the non-agreed order, maybe I'm still a little confused on the non-agreed orders.
okay. So
If a client goes in, he doesn't agree, they still prepare an order. I mean, we get clients that come in with these non-agreed orders all the time anyway.
So I guess my thing would
Once
be,
they
did
get
they
served, we
sign the
just file
waiver?
an answer. No, if they don't sign anything and they get served with it, we
Okay.
just file a response, a general denial answer, right? And that
Right,
would
and
be
so-
sufficient to be able to get into hearing.
Right. The courts are supposed to consider any kind of written document. And I mean, it can be anything. It could be a love letter, right? That says whatever, but the court's going to consider that as a request for a hearing. Okay. And it's got to be within 20 days for it to be considered timely. Now, because the non-agreeds are kind of have their own little personality, I'm really lenient. Before I even sign a non-agreed child support review order, I'm going to look to see if there were ever any answers filed or any requests to see. And if I happen to see something, I'm going to set it for a hearing. You know, because there was obviously something was going on. It's hard to, you know, some times are tough. It's hard to get the money to hire a lawyer. And so I get that. So when I sign it, I'm looking to see if there's any pleadings out there, any kind of a request for anything on this case, and then I'll set it for a hearing. And I usually try to set those within 2 weeks when I've noticed it.
Okay.
Yeah, but they're kind of funky. But if you do nothing, then it's going to be signed, and then the only recourse
And
you have is
confirmed,
motion for new
right.
trial.
Miss Nichols has a question that I've often wondered myself, but
Yes.
how can a judge sign an order with no evidence and no hearing to find best interest on the statutory findings on child support? I'm presuming she means on those non-agreed.
Right. So everything on a petition for a non-agreed child support review order, you're going to have the petition to confirm, and everything needs to be on there regarding income information, paternity tests, any of that stuff. And then it's kind of inferred that this is the information that's going to be in the best interest of the child, because it's to promote agreements, it's to promote parties to be together and talk together and try to work out an agreement. It doesn't always work out that way. So it's really important, if they don't agree to something, don't sign anything. Let the court aware that you want to have a hearing and have your say in court.
What if they file those waivers and they think, okay, well, I'm just going to wait for that court hearing now, not realizing that waiver allowed everyone to proceed without them?
So on a waiver, there's two waivers. There's one that Judge Strathmann had talked about where it specifically states, I agree to the terms of this order. And that's on an agreed CSRP. But if a party doesn't agree, and they need to talk, they need to voice their opinion. I know it can be really scary when you talk, just like when they're in court, they're nervous, they're scared, but if you don't agree, you gotta say, I don't agree. And then you might get talked into signing a waiver. And it's the one that says, okay, well, I agree to appear in court on any of these unresolved issues at a date and time, yada, yada, right? But those waivers typically don't have a date and time. And so when I get those on any non-agreed child support review order, I'm going to look to see with anything filed, and then set those for a hearing.
We are going to, the Office of the Attorney General is going to do a CLE presentation on all of the weird little worlds, like things are done a little different in the world of the OAGs. And so at that time, I think we'll probably ask Judge Martinez Gonzalez and Judge Strathmann to also be present at that again, so that we can address any outstanding questions you all still might have on that issue. I did want to reiterate, I think one of the things we started off with at the beginning of this is that the days where you got your kind of rubber stamped order from the Title IV courts, those are no longer the days. Judge Martinez Gonzalez and Judge Strathmann, both of them recognize, and the OAG recognize, that the presumption of there being a geographic restriction is the presumption that needs to be overcome. We all recall those days where you would get these orders from 6 or 7 years ago and nobody had geographic restrictions. Those days are gone. And the OAGs are aware of this too. If you come in there and your client says, I have 4 days off and I want to have those 4 days off visiting with my child, you're going to get much more receptiveness from both the Title IV courts in those. So I think thinking about the fact that they can hear anything that is custody related, possession and access related, child support related, they have that ability to do that. And since the philosophy has now changed over the years so that they are treating these cases much more like other family law cases, we're really hoping that we can get the family bar to start considering, having some of their temporary orders, if there's OAG involvement, of course, at least out of the 383rd. I can't speak for the other courts, although I know Judge Rodriguez is of a similar mindset, and I would welcome him to pipe in if he wants to, that he would want the Title IV courts in his case to be as creative as we are in ours. Ms. Thomas has a question. Is there still the ability to object to the associate? Yeah, it's the same objection statute. Now, if you come in and we think everybody is going to get upset and we're going to have to do this twice anyways, in the interest of judicial resources, Judge Strathmann or Judge Martinez Gonzalez may decide to pop this case up to the referring court anyway. Now, they may decide to go ahead and render some temporary orders, because they have that right by statute to on their own motion, without pleadings, enter some temporary orders. And my court specifically is encouraging that, so that we can make sure we don't have 4 or 5 months pass without a non-custodial parent having access, just because it may take, a couple of months to get a half-day hearing with us. So we have requested from the 383rd that both the Title IV courts do enter temporary orders pending final hearing so that we can at least get things started.
Okay. Sure.
And the same rules also apply. You can't object to them on temporary orders. So they can hear temporary orders just like any other case. So any other questions? And I think we'll, like I said, we are going to have an OAG CLE. Hopefully by the end of the year, we might, with the holidays coming up, we need to get with Miss Edwards and see how that's going to work. And I know that the Family Bar has a couple of CLEs coming up as well. So we don't want to overload you all with that. And we will definitely upload some directions on Dropbox and exactly how the process goes through a video. We just wanted to sort of give you all a taste of it right now as we start segueing into that. Any questions, any input, any advice, anything that y'all would like to see us do more of, better, different?
Judge, just so everyone knows, the MCL, this is offered for MCLE credit. We have 1.5 participatory and 0.5 ethics approved. Some of you have very strange names assigned to your devices. So I don't know who mom is. And if you could change your name on your device while we're still online so that the list populates correctly, I'd appreciate it. Otherwise, it's hard to report you.
And if you all have any thoughts, as I said, I did get some input from the Family Bar on other Dropbox type folders that you think might be of benefit. We would be more than happy to consider those. These were not at all, by any means, all encompassing, but we thought the more folders, the more confusion, and the more likely you're not going to be able to figure out which folder places go. So we appreciate you bearing with us and as we, I guess, navigate these transitions. And thank you all. And if there's no questions, y'all are excused. And this has been recorded, and we will have it up on our YouTube channel, so you can have your staff members and share it if you missed any part of it or you were unable to attend.
Okay, thank you.
Thank you.